Good morning, and thanks to those of you who scraped the frost off your windows and got here already for the beginning of our symposium. I'd like to welcome you to the Symposium on Religion and Conscience in Court. This symposium is taking place under the auspices of the Pluralism, Religion and Public Policy Project here in the Faculty of Religious Studies, and of the Kennedy Smith Chair in Catholic Studies, with additional sponsorship from the Center for Research on Religion and from the Faculty of Law. So on behalf of all of those, let me welcome you. I am Douglas Farrell, the current holder of the Kennedy Smith Chair, and from 1998 to the present, a member of this faculty. Dr. Yves has for over 2 decades worked in the field of public health, in executive as well as expert functions in the Department of Community Health at Saint-Luc, and in the Public Health Administration of the Laurentians region, at the Quebec Public Health Laboratory, and at the Public Health Protection Branch of the Ministry of Health and Social Services. He is a teacher at the Department of Social and Preventive Medicine at the University of Montreal's Faculty of Medicine. In 2003, he joined the executive team of the Collège de Médecine du Québec, serving as secretary of the order for the last 10 years. We're very privileged to welcome you and to thank you for your contribution, which we look forward to hearing in a moment. The speakers will speak in the order in which I'm introducing them. Next, Dr. Eugene Bereza, sitting to my immediate right here, the former director of the Biomedical Ethics Unit at McGill's Faculty of Medicine, and currently director of the new MUHC Center for Applied Ethics. Over the last 25 years, he has been formally consulted on more than 2,700 clinical cases at the bedside, often dealing with controversial aspects of end-of-life care. He has extensive experience in health policy development for the Quebec Medical Association, the Canadian Medical Association, the College of Family Physicians of Canada, and the Royal College of Physicians and Surgeons of Canada. He has testified before Canadian Senate committees, Quebec commissions, and the Supreme Court of British Columbia in the Carter case on issues including end-of-life care, palliative care, physician-assisted suicide, and euthanasia. Mr. Larry Worthen, to his right, has been Executive Director of the Christian Medical and Dental Society since 2012. His career has included a variety of leadership roles in the not-for-profit sector and also the Nova Scotia provincial government. He holds a law degree as well as a master's in theology. May your tribe increase. He is an ordained deacon in the Archdiocese of Halifax, Yarmouth, where his ministry is focused on pastoral care for the elderly and those close to death. And Professor Margaret Somerville, last but not least, of course, is the Samuel Gale Professor of Law at McGill, professor in the Faculty of Medicine, and founding director of the McGill Center for Medicine, Ethics, and Law. She is, as you know, a speaker, consultant, and researcher on topics such as euthanasia, reproductive technologies, mental health, human rights and healthcare, the pharmaceutical industry, AIDS, abortion, and the role that scientific and medical research and technology play in the formation of societal values. Professor Somerville is a Fellow of the Royal Society of Canada, and in 2004 was named the first recipient of the UNESCO Avicenna Prize for Ethics in Science. Among her books is Death Talk, The Case Against Euthanasia and Physician-Assisted Suicide. Her newest book, Bird on an Ethics Wire, Battles About Values in the Culture Wars, will be on sale by McGill Queens this afternoon during the reception, together with My Desiring a Better Country. The author, alas, will be in another country almost by then. That is, she will be out in my old stomping grounds in British Columbia, And we're very grateful that she's here with us now and willing to be with us in this session before the cab takes her directly to the airport. That's her life, and gives her plenty of fodder for speaking to people about mental health, no doubt. The newly minted right to assisted suicide, now coming into force in Quebec and about to be legislated federally at the behest of the Supreme Court in Carter v. Canada, has implications for the patient-doctor relation, for relations between doctors, for the work of professional bodies, for government oversight of medicine, and for the law itself. Its legislative implementation raises thorny questions of both policy and praxis. Philosophically, it queries our notion of human dignity and may alter our understanding not only of medicine, but of politics as such. Meanwhile, it is certain to test the nature and limits of the first enumerated freedom of conscience and religion. Our panelists, who are very distinguished and very qualified to speak to us and help us work through some of these issues, will address various challenges posed by this new legal right and by the regimes that will embody it, while focusing with the rest of us ultimately on the problem of conscientious objection, a problem the court noted it would certainly have to address on some future occasion.
I think at the beginning it's important to clarify some notions. The first one is there are three notions at the end of life that may be relevant to the discussion. The first one is the notion of withdrawal, withholding, treatments. This notion is not euthanasia. It is in cases where a patient can, and within our civil code in Quebec, that differs from what may happen in other provinces, which are in the common law. They have the right to take a decision against their good wealth. And for this reason, they have the right to refuse some treatments. So withholding, withdrawing of treatments is something that is already present in the Civil Code in Quebec since 1994. So it is an old matter in terms of medical decision making. The second notion is the notion of assisted suicide, which is quite different from what is going to be implemented by December 10 with the Quebec law. It is not included in the Quebec law, it is not accepted by the Collège de Médecins du Québec, and it is clearly a suicide. This means that the patient asks for the help of a third party, that may be the physician but maybe not, to help that person that is impossible for this person to put an end to her life without the help of a third party. In Oregon, this was the first state that had a law that permitted a physician to prescribe a little oral drug to a patient in order for that patient to take that drug later in time without the necessity of having a physician or a healthcare worker at its bedside. And this is clearly suicide, and this is clearly a process that may not be linked necessarily to an end-of-life natural process. And a person who has a physical condition where the patient feels that the quality of his life doesn't work to go forward, put an end to his life. And it is not in a context where death is inevitable and in the short term. And this is not a reality that will happen in the short term in Quebec, especially with the help of physicians. The third reality is euthanasia, and euthanasia in a case of end-of-life situation where a patient is in situation of suffering, psychologically or physically, and where death will happen in the near future. The law does not define what is the near future. They say end of life. That may be a matter of days, a matter of weeks, but it is a reality that will inevitably happen in the short term. And the Quebec law says that the patient may ask for that, but the physician has a responsibility And this is where the Quebec stands right now. The law that was adopted last year in June was a try of finding the best mix possible between what we call the logic of rights. Rights for a patient for asking the kind of care they want at the end of their life, and make it mandatory for other persons to fulfill these wills. The second logic is the logic of care. From our perspective as a regulatory body, we think that the physician cannot be limited in its action to be only a technician or a person who is just there to fulfill the will of the patient. There is a professional assessment that has to be done, and in this case, they have to be sure that all the criteria imposed by the law, which are quite restricted, are fulfilled before going forward with the request by the patient, including confirming that the patient is suffering from a grief disease, that the patient is suffering, that the patient is apt to consent, that the patient is an adult. He must be ensured in consistency with the health insurance law, meaning that this criteria was there essentially to prevent medical tourism for this only reason. And finally, the patient has to express not only once, but many times with a written decision that may be done with the help of a health professional to have access to medical aid in dying. And so this process is quite rigorous, and has to be made rigorous, and for which there will be a report made for each case. One of the questions that may be raised is not the beginning of something worse that can happen in the future. Well, the point is there are cases, although exceptional, where a patient cannot be relieved from his suffering with current usual treatments. This is a fact the college is aware of, and we know probably that there were acts of euthanasia that occurred in the past, but unfortunately under the scope of visibility. And if there is a risk of mismanagement, we are fearing a risk when there are no rules, no laws, to try to do a framework to have it and to control it in some ways. This doesn't mean that the law gives an absolute control, but at least it's better to have rules than no rules at all. And this is our point of view. And we think within our jurisdiction, where our Code of Ethics, Article 58, says when a patient arrives at the end of its life and the death is inevitable, the physician must provide death with dignity and provide a relief appropriate to the suffering of the patient. And in our view, the interpretation of this article from our part, because it is our jurisdiction of the College of Physicians, can accept that in some cases, some exceptional cases that are, as a matter of fact, included in the Quebec law, there is a possibility to offer, if not an euthanasia, at least a reduction of an intolerable and inhuman agony for a patient at the end of his life. We provided, over the last 3 months, 3 guidelines for the profession. The first one on how to manage the main syndromes at the end of life. A second one on palliative sedation. Not only continuous palliative sedation, but palliative sedation, because it can be either intermittent or continuous. And finally, one on the medical aid in dying, explaining in practical ways how the law could be implemented with physical tools. We were mostly inspired for this last one, that was, as a matter of fact, a multidisciplinary guideline made with the help of the Order of Pharmacists and the Order of Nurses. So it is a common guideline for healthcare professionals, and in that way it's a kind of model to try to accompany the patient until the end of his life. One of the important point that has to be raised in our Quebec law is the fact that there is an absolute need of professional aid and assessment of the patient, and the patient is not left alone at all. It is a requirement of the law, and the way the guideline is made, there is a need to have a physician at the bedside of the patient. And this is the spirit, at least, that we want to promote on this point. Now, the topic this morning was the ruling of the Supreme Court. It was unexpected from our part that the ruling, the Supreme Court had a unanimous ruling last February, that this ruling would have three effects. The first decision is to invalidate the two articles of the Criminal Code saying that offering medical aid to in dying, they call physician-assisted death in the ruling, is a criminal act or illegal. So these articles are made invalidated, and it will be implemented, if there is no change in the timeline, by February 2016. The second decision was to recognize the legitimacy of provincial and federal governments to adopt a legal framework to the implementation of physician-assisted death. And finally, they made criteria available to have access to this physician-assisted death, mostly the same as the one we have in Quebec, except for the major one. The patient, they didn't kept the criteria of the fact the patient had to be at the end of his life, which is a major difference between what will be implemented in Quebec and the ruling of the Supreme Court. Now, the ruling obviously made open the discussion between our colleagues and my colleagues in the College of Physicians in Canada, and there are many working groups working around trying to find and propose some answers to the ruling to make it possible and implemented in Canada. One of the things we are fearing at the College of Physicians, and probably we can discuss about that, is the fact that one of the scenario that seems to be interested by my colleagues in other provinces is the scenario of assisted suicide. The Supreme Court did not say that physician-assisted death had to be euthanasia. They said that there should be a physician there to assist the patient. It is interpreted in some provinces as the opening for the possibility of having a kind of Oregon-like assisted death with the prescription of oral drugs that could be taken by a patient afterwards in the future without necessarily the help or the assistance of a physician. This is a fear for us because it is less medically advisable that what we see at the end of life for a patient who is already suffering. So the door would be potentially open to patients who are not at the end of life, who have a physical condition where they can suffer, but where death is not inevitable. And this is the gray area we are uncomfortable with. And clearly in Quebec, this option will not be possible unless there is a modification of our Quebec law, which is not expected in the short term. So this is the main issue I wanted to, and we can get back to conscientious objection, which is another issue.
Indeed.
I want to focus my talk on limits of conscientious objection, if there are any now, and I'll focus on two specific articles that came out of the actual Supreme Court in Carter decision, Article 130 and 132. And basically, the key element here, let's just take 2 seconds to look at this. A number of the interveners asked the court to account for physicians' freedom of conscience and religion. They asked us to confirm that physicians and other healthcare providers cannot be compelled to provide medical aid in dying. They would have the court direct the legislator to provide robust protection for those who decline, and here's the key word, to support or participate, not just to participate, but to support and participate in physician-assisted dying for reasons of conscience or religion. And 132, In our view, nothing in the Declaration of Invalidity which we propose to issue would compel physicians to provide the assistance in dying. The Declaration simply renders a criminal prohibition invalid. And then I would go on and say, in making this observation, we do not wish to preempt the legislative and regulatory response to this judgment, and the emphasis is mine. Rather, we underline that the Charter of Rights of patient and physicians will need to be reconciled. And that's the key area I want to focus. How do you reconcile potentially opposing rights? And bottom line here, I'm not sure that one can ultimately reconcile two fundamentally different perspectives. My not-so-hidden agenda, I have two objectives here. Examine what, if any, limits are there to conscientious objection in this context, and secondly, what is the best strategy for palliative care moving forward? And I list both of them because I think these are intimately interactive. My personal concern, my personal agenda, is what is the threat of the current Quebec legislative process to palliative care going forward. Why am I concerned? I guess it's probably because I was trained in palliative care by Balfour Mount, and so I have a deep commitment to making sure palliative care survives this in some fashion. Not only survives, but grows and evolves, and that is the real concern. So, first section, limits conscientious objection, if any, and here's what I feel is a dilemma. There can, and often is, in my experience working in a clinical context, a conflict between a personal identity and a professional identity. The first time I was made aware of this very bluntly was by a colleague who in fact sat with me on the College of Family Physicians Ethics Committee, who happened to be a devout Catholic, and said to me, Eugene, you don't understand. I didn't. Catholicism is not something I hang up at the door as I walk into my clinic. It's part of who I am. And so you can ask me to give up my personal value framework, hanging up like a coat at the door when I put on my white coat and walk into the clinic. That makes me schizoid. It just doesn't work. And that really struck home, saying, well, that makes a lot of sense. From a patient's perspective, however, they're saying, as a patient coming to the hospital, I shouldn't have to care or worry about whether you're a Catholic physician, an Orthodox Jewish physician, a Mormon physician, a secular physician. You have sworn an oath of the code of ethics of the profession. That's equally a very strong code. It's not just some secular thing you wipe away. So you have made two allegiances morally. One to your personal moral view, and one to professional moral view, which may be, theoretically, irreconcilable. How do you manage that? So just to make the point a little more clearly, a personal identity linked to a specific moral code and allegiance to a homogeneous moral community. If I'm a devout Catholic or a devout Mormon, I have a homogeneous community. I have an allegiance to that moral view, which makes perfect sense to me. From a professional identity is linked to a specific moral code of ethics of the Collège des Médecins, in our case, in the service of a morally diverse society. How do you reconcile those two? Another way of stating the same dilemma is you have a right to conscientious objection, which I actually very much strongly support. The rate of burnout among healthcare professionals is quite high. Doctors, nurses, social. It's not because of money or decreased salary. It's because we are sometimes we're compelled to do things we don't believe in or we think is wrong. And here's one example of that. At the same time, there's a fiduciary duty of care. Now, one way, among many, of defining what is a fiduciary duty means patients have to have a sense of trust in their physician or healthcare provider, knowing that the physician will put the care and interests of their patient ahead of their own personal ones. How does that help us reconcile those dilemmas? Last version of the same dilemma, I think, is some would argue, and this speaks to the notion of how you perceive ethics itself, the consistency of philosophical argumentation. So if you believe in the notion of conscientious objection, you should say, I should not be compelled to do anything, if I'm consistent philosophically, that would violate my conscience. Another way of looking at ethics is, That's great when you have such discrete moral parameters. But what do you do when you actually have competing moral values? And you have to somehow manage those. You can't just say, this one is all wrong, this one is all right, the champion wins. We have to manage competing values that each have some legitimacy. How do you prioritize those? So let me look at the argumentation of consistency of argumentation from the point of view of conscientious objection. And there's a range of where you might draw that line on a spectrum. So you could say, well, if I conscientiously object, I can do the following. I can withdraw and pay the personal price. In other words, I want to have nothing to do with medicine anymore. If medicine's going there, I take down my sign as a practicing physician, I'm out of that. Something Sigmund Freud did, by the way. When he felt that the Austrian Medical Society disagreed with his view of mental health, he said, fine, I'm no longer a member of the Austrian Medical Society. Second, you say, well, in this case, I'm not going to commit the act, but I will refer. So I will not provide lethal dose, but I will refer it to Jack. And some have pointed out, well, that's not very consistent. It's like saying, I don't happen to murder people, but I know Frank does. Here's his address. Aren't you morally culpable in the same degree, or a similar degree? A third element in terms of act would be, don't commit and don't refer, because it would be inconsistent to refer. What does refer mean? So in our case, the hospital may mean, if I'm asked as a physician to provide, I can say, I won't do that, and I won't find another physician to replace you. Or it can mean, I won't do that, and I will tell you who the authority is in the institution that can find you one. Or it can mean, I don't do that, period, and not have any further discussion. They all fall under the notion of not referring. Which version of not referring is acceptable? Finally, you can say, I don't commit the act, I don't refer, and in terms of consistency, I should morally engage in an ethical version of civil disobedience. At every opportunity, I should make the case of showing why society made a mistake and should reverse its course. And finally, and I put this deliberately to the other extreme, don't commit the act, don't refer, and engage in, quote, whatever means necessary to undermine a democratic process. And certainly we see in our world today what happens when you go to that extreme. So my question becomes, what is the best strategy for palliative care going forward? And my point here is I think we have to have a cautionary tale. I actually appreciated your vision of Thomas More in the pamphlet you distributed. And but there's another version, and that is of Savonarola. So Thomas More, one of the best known humanists, who, if anybody of you watched the movie Man for All Seasons, clearly paid the price. He basically withdrew and said, I am the king's servant, but God's first, and if it means I have to lose my head, so be it. But his approach was very much to the left of that spectrum, saying, I'm not going to commit acts of civil disobedience. I will not try to rally the troops and overthrow the king. Separation of church and state. If that's not for me, fine, I'm not going to do it. The rest is their problem. As opposed to his contemporary Savonarola, infamous for bonfire families, who said, I have a direct line of communication with God. He spoke to me, and everybody else is wrong. Now, he was living in a time of great corruption of the Medicis, and he had a legitimate point. It was a corrupt society. It went off the rails. Unlike his compatriot, he decided that he had the absolute vision of truth, and everybody else would be obliterated. What happened to Savonarola? He also died, but in a very different way than Sir Thomas More. So my question to you is, a lot of people in the palliative care community say, a big threat, the biggest threat to palliative care is this legislation, Edemoya. I wonder, it is a threat. My concern is this is the bigger threat. Ideological fundamentalism. Now, I have yet to see anybody in Quebec in the camp of the Savonarola. But there are gray zones, and I have specific examples I could use to challenge us and say just how strong is the rhetoric in undermining a democratic social process. And so these examples maybe we'll have time to look at later, but the question is, will there be a Pyrrhic victory where those individuals are so fundamentally opposed know that they have been consistent with their own worldview, they may end up sinking the ship of palliative care by alienating everybody around them. How much time do I have left? I can give you a couple of specific examples.
You've got 1.5 minutes.
1.5 minutes. So here are examples of where I think palliative care is becoming its own worst enemy going forward. Individuals who say things like, if we have a consult for a request for aide à mourir, and I, as an ethicist, say, I'm not sure this patient is well informed of their other options, like palliative care. Can we have a palliative care consult so the person has an enlightened decision? And this is the direct quote, I would refuse as a palliative care physician to do that consult. I have nothing to do with that kind of case. Seems to me you just shot palliative care in the foot, not to mention undermined enlightened consent for the patient. Second example, and these are direct quotes that I've experienced personally. If there's to be any future teaching done about how we go forward in our society, I will not be in that room to participate in that teaching. So if we're going to be teaching our junior medical students and our residents about the new law, I refuse to be there. Well, isn't that wonderful? So the students will be receiving education about aide à mourir without the benefit of the palliative care community being there to say, here are the other options. Third example, people who are physicians who feel totally legitimately fundamentally opposed because of conscientious objection to this law use public platform in their official capacities to undermine due process, i.e. they'll come in from the College of Physicians executive and say, we cannot pass the government-required regulations to change the code of ethics of the institution, and then dominate the conversation to not allow for both sides to be understood. How fair is that in a democracy? Now, the democracy, at the end of the day, as we all know, is not a perfect process. Not a day goes by as a clinician when I go, oh my gosh, this law doesn't really make sense. Do I agree with it? But we all know it's probably better to know it's second best. And my concern about second best is that we forget about the vision of church and state and say an oligarchy of moral purists will supersede it. So I'm being deliberately provocative to see how we're moving on that. Thank you.
Perfect. Thank you very much. It's quite an honor to be here with such a distinguished panel. The Christian Medical Dental Society is an organization of 1,700 Christian physicians and dentists across Canada. And we, of course, our organization is very concerned about conscientious objection and, of course, the passage of the legalization of assisted suicide and euthanasia. I'd like to begin by stating clearly that when it comes to the Carter decision, our members are most concerned about the welfare of vulnerable patients. I noted the difference between the Quebec legislation and the Carter decision, and as a lawyer, I am concerned that the Carter decision will probably override the Quebec legislation in terms of end of life. And we certainly, as a matter of harm reduction, have suggested that it be restricted to terminal cases. So in that sense, even though I don't agree with assisted suicide and euthanasia, we felt that that would be a mode of harm reduction, and we're concerned about the extension of the Carter decision. But they're also concerned, our members are also concerned about their capacity to be able to serve their patients. This is a real concern because earlier this year, the Ontario College of Physicians and Surgeons passed a policy on conscientious objection that required physicians to provide an effective referral to patients for procedures that go against their conscience. And we've also had a similar policy passed in Saskatchewan that not only requires physicians to quote-unquote make arrangements, but also in some cases to actually perform procedures that go against their conscience. While both of these policies technically don't apply to assisted suicide and euthanasia, our concern is that that will be the logical extension and will only be a matter of time. In addition, we're also concerned about the provisions of the Quebec legislation that require physicians to pass forms or to refer to a third party, a government official, in cases of conscientious objection. We're concerned because we feel that that also restricts conscience protections. It's not all bad news. We have 4 colleges right now, BC, Alberta, Manitoba, and New Brunswick, who are putting forward policies on assisted suicide and euthanasia and conscience protection that we feel are quite favorable. We've been dealing directly with those colleges, and we've had a very positive result. Our members have 3 concerns related to conscience. They don't want to be compelled to refer for procedures that go against their moral convictions. They don't want to actually have to perform procedures that go against their moral convictions, and they don't want to be discriminated against because of failure to provide those procedures. And we're concerned, especially the way the Quebec legislation is laid out, that since end-of-life care, there are 3 components, including medical aid in dying, that there may be in future years a push to discriminate against physicians who are not prepared to provide the full suite of services. Many doctors have moral convictions on assisted death that come from their professional judgment, the Hippocratic Oath, or their religion or creed. It's not just Christians that have this concern. Jewish and Islamic faith traditions joined with Christians recently presenting a declaration on euthanasia and assisted suicide. And their declaration called on policymakers to protect the conscious rights of healthcare workers who cannot accept assisted suicide or euthanasia as a medical condition. I predict that as the criteria in Carter are played out, that many physicians will actually, even those who are in favor of euthanasia, perhaps under limited conditions in the Quebec law, will be shocked to find out who is eligible, because the legislation allows people with disabilities, including people with mental health problems, to be euthanized. And I predict that as that rolls out in the next generation, there will be many physicians who, while theoretically in favor of assisted suicide, find that they are no longer able to accept it in particular circumstances, because there will be people coming forward who have disabilities, who are not at end of life, have the possibility of prolonged life, but yet are choosing to choose assisted suicide or euthanasia and end up ending their lives. I think there will be doctors who will want to not be forced to refer into those circumstances, and even those doctors will need to be protected. And we would like to reiterate the following 4 reasons why we feel it is not in the public interest to require members to refer for assisted suicide or euthanasia. First, for many physicians, even referral to a third party, means approval, recommendation, and facilitation by the referring physician for something that the physician feels will harm the patient. This essentially amounts to participation, which is the wording in section 132 of the Carter case. I chose to emphasize different sections than you did. But it's clear that the Carter decision itself says that no one can be forced to participate. Participate for us includes referral. It also says that it's a matter of conscience, and conscience is a freedom protected under the Canadian Charter of Rights and Freedoms. The Carter decision allows Canadian citizens to ask physicians to end their lives, but is it fair for the same citizens to require that an unwilling physician be forced to aid and abet them in this practice? This is what others have suggested, ironically under the banner of choice. To require referral would be to force our members to act against their moral conviction that assisted suicide and euthanasia is intentionally harming their patients. This would threaten the very core of why they became doctors in the first place, which is to help to heal people. We do respect patient autonomy, however, and the right of patients to make their own decisions in their own health care. So our position is somewhat nuanced along that spectrum that you identified. We simply ask we not be morally implicated in their decisions which go against our conscience. The Christian moral theologians have clearly stated that referral is participation in an immoral act. We've checked with the Canadian Catholic Bioethics Institute, the National Catholic Bioethics Center in the United States, several evangelical theologians. Cardinal Carter of Toronto made a statement on this, and the Canadian Conference of Catholic Bishops asked for conscience protection for doctors so that they would not have to make referrals in this case. Everyone acknowledges that there is a strong body of opinion in Christian circles and amongst other faiths that referral in itself is participation in an immoral act. A requirement to refer would therefore drive some physicians out of practice areas where they might be required to refer, and this is a clear fear and concern amongst our members. And we would argue that it's not in the public interest to remove from the practice of medicine a whole group of people based on their moral convictions. This does not create a more tolerant or inclusive society. It is in fact discrimination. Now, the use of the word reconcile in paragraph 132 of the court's decision, we do not feel that reconcile means wreck. We feel that it's possible to create a system where both the right of the patient to access, to follow their autonomous medical decisions and the physician's conscience protection can be done at the same time. We think Canada is a tolerant enough community to be able to come up with creative ways to do that. We've developed a proposal, and I also want to mention there is no right in the charter that would require a particular doctor to provide a particular service to the patient. In other words, it's not the responsibility of every individual doctor to ensure access to every possible procedure. It is the responsibility of the government. If the government decides, as they've done in Quebec, that this will be a medical service, then it is of the responsibility of the Department of Health to ensure access to that service. The onus should not be on individual doctors. Now, we've developed a proposal that demonstrates that both patient autonomy and conscience rights can be respected at the same time. We did that in conjunction with the Director of Ethics at the Canadian Medical Association, and we presented them a 4-page proposal that outlines how this could be done. And that proposal was approved by the membership by a 2/3 vote at the CMA conference in August, and then was eventually approved by the CMA board. And it is that proposal that's being followed by the colleges that I'm talking about in the Western provinces. The proposal simply requires that the patient have direct access to a service that would provide them with an assessment once they have discussed this with their doctor and clearly decided to seek assisted death. Our members are not shooting themselves in the foot, as some that you've complained of here in Quebec. But what we're simply saying is that we are comfortable providing the patient with all information on all options. Our doctors do not want to abandon their patients. They want to be with the patients and help them work through this difficult issue. But once the patient decides that this is the track they want to take, and we simply ask that there be referral service provided by the Department of Health, that these patients can contact directly on their own and seek that assessment through this referral. A similar situation is being set up in Quebec. We simply ask that rather than requiring the doctor to be the one to forward the documentation, that the patient be allowed to access that service directly. We feel that this proposal could very much do everything to resolve the conscience concerns of our members. Our members are prepared to continue to serve their patients and even help them by providing other health services other than assisted death. Because we do accept the concept of autonomy, we simply ask that rather than an either-or scenario, that it be a both-and scenario, that conscience rights be protected and that patient autonomy be preserved and protected as well. We feel that governments need to step up and find mechanisms, such as the one we've outlined, to respect the autonomy of the patient and the conscience rights of the physician. If access to assisted suicide is through a referral and information service, then individual doctors would not be required to do referrals to ensure access, but could provide all other manner of cooperation with the referring physician to be able to facilitate an effective transfer of care. Finally, the fourth quick point is that public opinion does not favor forcing physicians to refer. We've done extensive public opinion surveys all across Canada, and we found that where an additional option, that is the option of providing information and patient direct access to this assessment service, that a majority of Canadians support that approach as opposed to forcing doctors to refer. We feel that health professionals should not be required to participate in assisted death or refer for it or be discriminated against because of this refusal to participate. If we truly are a pluralistic country, then there should be respect for all religious traditions and backgrounds, and even for those who have no religious tradition but also are concerned about participation in this. And we feel that there is sufficient creativity within Canada to be able to come up with a proposal that allows all of us to continue to serve patients with our moral integrity intact. We also feel, in closing, that all of the conclusions that we've drawn with reference to conscious protection should also apply to any other health professional who does not want to be involved in assisted suicide and euthanasia. I look forward to discussion on some of the points.
Well, one thing about going last is that you can skip a lot of the stuff that you've prepared. But I just before I start on what I want to say, I have one radical solution to all that we've heard the problem, and that is to get this right out of medicine. That if society wants it, and if people think it's necessary, I propose that we should have a group of specially trained people who are willing to do it and will carry it out, and that it is not classified as medical treatment. That means you avoid your palliative care problem, you avoid your physicians, nurses, pharmacists, and everybody else conscience problem, and you make it a separate endeavour. And I think if we want, I also think that is useful because it takes the white cloak off euthanasia, and it allows you to react to it in what I believe is the essential way, that your decision is informed not just by logical cognitive reasoning, but it's also informed by moral intuitions and what I would call examined emotions. And certainly when I've been lecturing on this, and I say things like we can't have physicians killing their patients, people get very upset with me when I use the word killing. But if we can't face the reality of what we're doing, then we should be warned that what we're doing is the least highly questionable, and I believe is wrong. Now you'll see in my title that there's a lot of words starting with C, and why that is because the connection is that all of those issues were involved in the Carter case. The Carter case essentially focused on the intense suffering of an individual person, and what it did, it said it was cruel to leave a person like that, and so it opted for what it saw as kindness. The morning after the Carter case, the whole front page of the Globe and Mail had a photo of an orderly, probably, or a carer, pushing a wheelchair with an old person in it down a misty corridor. Both people had their backs to you. Across the photo was written, "Towards kindness." And so I think that's the other thing that we have to deal with, to get the competing emotions. Now, as well, to understand about freedom of conscience and the battles about it, you have to understand a much bigger context. And thank you, Doug. Doug gave an advertisement for my book. I brought a copy of it. I didn't know it was going to be for sale here. And that's what that deals with. It deals with battles about values in the culture wars. And essentially what is happening is that we've got a conflict between people who call themselves progressives and people who are more conservative or have traditional values. As a matter of fact, what the progressives call, I'm one of the second group, what they call us, and a term that I heard a Supreme Court of Canada judge use recently in a conference, they call us restrictives. Well, that means that they're permissives, but they don't use that term. And so, what about freedom of conscience? Here it is. It's freedom from being forced to act contrary to what one believes, or, and we haven't talked about this, prevented from doing what one believes to be required as a matter of conscience. Moreover, freedom of conscience is a right. It's in the Charter. It's a very important right, and it's not just a privilege for physicians. To the extent that you are impinging on freedom of conscience, you're impinging on the right. And moreover, that right, as is true of a lot of the rights in the Charter, perhaps all of them, is not meant just to protect the individual who claims the right. It's also meant to be a safeguard and benefit to the patients that are looked after. Now, despite that, we're seeing legislation and professional codes that are overriding physicians' freedom of conscience. What I've got next, Dr. Bereza has also already shown you. I too took out the relevant passages from the Supreme Court judgment. And here you see I've put in bold what I think is important, may be obligated based on a duty to act in their patient's best interests to do this. And the court, they ask the court to direct the legislature to provide robust protection. So what does that mean, based on a duty to act in their patient's best interests? Obviously, physicians who object to euthanasia or physician-assisted suicide don't see it as in the best interests of their patients. So it must mean that they would be bound to do so if other physicians or other authorities saw it as in the best interests of patients. And I'd also make the point there that there's a difference between being in a patient's best interest that they die soon. I think that happens a lot. I've just been through it personally with my 94-year-old aunt. She kept saying, please God, let me die. And you wish that she could die, but that is very different from wanting to be killed. And I think there's a lot of confusion between that. And then they say as well, cannot be compelled to provide medical aid in dying. And so that brings up what constitutes medical aid in dying. So let's look at the next paragraph of that judgment. The Canadian Medical Association said it wanted people to be able to follow their conscience, and they wanted the legislative scheme to reflect that, and they said that they must legally protect both physicians who choose to provide this new intervention and protect those who do not choose to provide it. So, at first glance, it seems okay, the rights of physicians within the bounds of the law, that their policy will be not to force them to do something they don't want to do. But then effective referral is then defined. And one of our speakers has already told you what that is. The problem with that is that you do have to become complicit. That's the definition from the College of Physicians and Surgeons of Ontario. And so that is participation. If you want a recent example of where you can see that being participation, the 90-plus-year-old man who was the accountant for the Nazis, who tabulated all of the money and jewelry and everything that came from the people being sent off to the concentration camp. He was relatively recently convicted in Germany of complicity in the Nazi war crimes and guilty of war crimes himself. So we've got plenty of examples outside this context that is a normal way to proceed. And here's what the Supreme Court says. They say nothing we say is meant to compel physicians to provide assistance. What follows is in the hands of the colleges, as we've seen from Dr. Robert. And we say, however, that we're going to have to balance or reconcile the rights of patients and physicians. So what does this mean? First of all, the first thing it means is that the Supreme Court is passing the buck. It strikes down the prohibition on assisted death or assisted suicide, actually, but it rules that it's for others to implement the judgment. And I think that raises a lot of problems if those others say, well, we want to compel physicians to at least refer because that's complicity. And what does the last sentence mean? That the rights have to be reconciled. Physicians have got rights of freedom of conscience, but even in medical treatment, the patients have got no outright rights to demand it. And there's no right to commit suicide, which is what people would be doing under the Supreme Court ruling. So, and then do patients have a right to have physicians kill them? And what if they can't be reconciled? And another issue that I've just actually been discussing with some other people is if under the regulations, judicial approval is required of each incident of inflicting death, well, do judges have rights of freedom of conscience? And actually that's something I've never thought about before and I've never heard discussed after I've been in a law school for 40 years. And so it'll be an interesting issue. Now, so progressive Progressive values advocates believe that individual autonomy always takes priority over other values, and especially if they can label those values religiously based. And the Supreme Court very strongly upheld that individual choice about one's own body or life is preeminent, and others must respect, and this is where we get into trouble, and implement whatever that might be, that choice, even if it's contrary to their conscience or religious beliefs. And one way that this is being promoted in the medical law literature and the medical ethics literature is to say that physicians are mere technicians and they've got no rights to make ethical or moral judgments about what their patients want. And it's the same as taking your car to a mechanic to have it repaired. If you say you want the wheels changed, if he says he won't do it because you're of a different race, for example, then that's discrimination. And they say this is exactly the same. If the physician says they won't do what you want in terms of inflicting death, then you're discriminating against them. That is a wrong legal argument. The reason it's wrong is that the physician is not refusing on the basis of any characteristic of the patient, and he's not giving the service to one person and not to another, which is true of the car mechanic. What he's saying is, I won't do this because of my own reasons. Now, another feature of the progressives is tolerance, and they really tout tolerance for everything. If you want to read about this, chapter 2 in the book. But in reality, many of them are tolerant only when you agree with what they think is right and the values that they want. And so what they want to do is to impose on people who don't want to do these procedures that they do them. And you can, here are some examples of where that is happening. I won't go into them. The Quebec Act is an example. The Ontario College of Physicians, in requiring effective referral, and the Ontario Human Rights Commission as well. And what are the consequences of the refusals? Well, there's a variety of legal threats. There's first of all discrimination charges and damages under human rights codes. There's a possibility of professional misconduct, which means that your license could be revoked. Dr. Robert is often involved in that sort of inquiry because it's common in the colleges. And then penalties, and you could lose a license to practice medicine or to practice as a nurse. I suppose it's also possible that you could allege medical malpractice. So how should we respond? I suggest that, first of all, and this point has been made, physicians who believe what they're doing is ethical should not be drummed out of the profession. Perhaps we can have a list of physicians who are willing to do this and a list of those who won't, and people can choose. I also think that we need euthanasia-free zones in our hospitals and residential care facilities so that people don't have to be frightened that if they go in there or if they consent to proper pain management, they're actually going to be killed. That is not just a fear that I've made up. We know that people in the Netherlands and Belgium are refusing adequate pain management because they fear that they will be killed. In fact, research shows that some physicians have indeed killed people without their consent under the guise of giving pain management in those jurisdictions. So, oh gosh, I really, because there is, anyway, well, I'll skip this. The ethical cleansing, what is happening here? Well, what is happening here is that we've got an ideology that is trying to impose itself. The reason that the people who've got that ideology will not tolerate an exception for freedom of conscience is because they see that as a rejection of their ideology and they don't want to have that. Indeed, it is by forcing the people who do object to do what they want done that their ideology is affirmed. And there's a lot more that could be said about that, but thanks.
Okay. What I would say is that from our perspective at the college, we don't feel that conscientious objection is so much important in our membership, and it's mostly exceptional than the rule. The second point, answering to comment by Mrs. Somerville, is that if it will be very hard to exclude physicians from this process, and probably what will happen in Quebec is what is already happening with abortion. Most women who want abortion don't go to physicians who are already known as being against abortion. There are clinics already well identified that provide this procedure where women go precisely there. So I think it's some kind of, as I see it right now, and from our 9 years perspective of working on this point, that it's not a major issue. I saw this issue of conscientious objection more prominent when the discussion went out of Quebec. Usually, when I have Canadian discussions on these issues, the first topic to discuss is conscientious objection of physicians. It was not the first issue in Quebec, I must say that. It was really the issue of how to answer the request of patients, because there was a request from most patients. So how to organize it to make well-being of physicians who have objections and the requirements of patients, probably the real issue. It's not the fact to respect that or not, because there are provisions in the law and in the Code of Ethics of Physicians that the conscientious objection is there. And the major point is that it has to be expressed by the physician as soon as possible when it is expected that the patient will require it.
One of the questions I have actually for you, because I think it was very interesting, unfortunately I'm at a disadvantage not having seen the document you proposed to the CMA, which would be very interesting. The notion of the vulnerable patient, and again I think vulnerability is not a homogeneous group, there are all kinds of vulnerabilities. So my concern is if there was a way to manage that, I agree with you, so that both are not violated, that's the ideal solution. And I think certainly at the NUHC, where I have some role to play in trying to figure out how we do that, we're trying to come up with a mechanism that would, I don't know how to articulate this, but at least violate conscientious objection to referral, to be done in such a way that you feel the least compromised. Having said that, from my perspective in the front lines, I don't know how many of you have actually been to the new hospital, or those who ever worked in a home care setting. I can see scenarios where, again, not all patients dying are surrounded by loving, devoted family members who are informed and sophisticated and articulate and know how to advocate. Some of them are totally alone. If they are truly imminently dying, as is the requirement in the Quebec legislation, then they're often fairly weak and vulnerable. Or they're at home alone. And it's very hard for me to imagine how that person would navigate at the MUHC or at home a scenario where they're asking for what they have as a legal right, and the physician is not compelled to refer. So what would they do to that person who would probably have a week left to live anyways and is in a bed not able to move? There's information out there about this act. You have certain rights, but that's as far as I'll go to inform you. You figure it out on your own. How does that person access their rights? So to reconcile that would be it'd be interesting to see how that's managed in such a way that both parties are protected. I think those patients are equally vulnerable. Those who don't want to wait for death to happen, those who want a subjective patient's perspective. It's in my best interest to be killed, although I don't want to do that.
The problem I have in this is that we are a minority group, okay? We are a minority group. I agree that there are a minority of physicians in Quebec who are concerned about conscientious objection, Dr. Rivera. But the concern I have is that the college and other decision-making bodies, even your hospital, we don't have any evidence that anyone is consulting the minority group in this to see if we can work through ways to respond to this. The problem I have is that, and this happens to me all the time, I'm fortunate to be on this panel, often I don't get invited, but I have to sit and listen to people pontificating about what is ethically, morally right or morally wrong for somebody else who's not even in the conversation. We're outside of the conversation here. I think that there are certainly ways. Patient representatives would be one way, but there are other creative ways that we could find to ensure that people get access. But I think that we're not going to get that if there's no dialogue. And fortunately, we did have the dialogue with the CMA, but I think we need to be part of the conversation.
Professor Somerville.
Yeah, Dr. Robert, I might be wrong on this, but I thought I saw in the guidelines that you only anticipate that a doctor would only do one medical aid in dying a year. Is that correct?
It's hard at this point in time to make perspectives for the future. We don't know how many demands we are going to manage, probably much more than acts, because we interpret right now that if a patient who will ask for a demand is under the false impression that it is euthanasia on demand, which is not the case. The demand is the first step, but it has to be managed through the requirements and the criteria of the law, asking for a physical assessment of the patient, for a second opinion of another physician, and so on. And so what we interpret right now is mostly at the beginning, the demands will be demands not mostly for having medical aid in dying, but for having, expressing a suffering and asking for information. This will be the first demands we're going to have. And what I used to say to most physicians I'm doing lecture to is probably the most frequent thing you will have to do is to explain to a patient why he will not have access to medical aid in dying, because of the so restrictive criteria we have in Quebec compared to what is expected with the application of the ruling of the Supreme Court. So we don't know how many cases in reality we're going to have, but it's going to be very exceptional. And if I have to put a number, it would surely be less than 100 by year. So calculate.
Well, yet you purport to base your legislation on the Belgian experience and the Netherlands. Okay, well, let's do the Netherlands. Currently, the official figure in the Netherlands of death by euthanasia is 4% of all deaths, and that is a very substantial underrepresentation because the deaths that occur without the consent of the patient in the Netherlands are not counted as euthanasia. The estimates are that it's somewhere around 7% of all deaths. And if that was the case in Quebec, we'd have thousands of deaths by medical aid in dying.
I must say that there are major differences between Belgium, Netherlands legislation and Quebec legislation, which is quite more restrictive in Quebec than it will be in other regions. So don't leave the impression that it is a wide permissive law. It is not the case.
So,
Well, at least I think we found one thing we have in common, is we both object to pontification. I guess I'm not sure about the argument about the minority. I think there's a question of perception here. I don't doubt that there's a perception we're in a minority and we're not being here, we need to be at the table. And if that's the case, then I think that's a legitimate claim. While we do not have anything near like a scientific study, we tested the waters at the MUHC to see who's on which side. So these are not reliable numbers. It's more to, in fact, the minority are the physicians who are in favor. The majority are the ones who are actively, I'm being provocative, pontificating that is completely unacceptable under any circumstances anywhere. So who's in the minority, who's in the majority, who's pontificating, I think is often from where you're coming from to start with. But I would say it's the minority of physicians who are less than 15% would be willing to participate from, but that's a rough number. So I think we both agree, but we see it from a different perspective.